What does a game publishing agreement look like? It looks like a big long contract, and so I have such a contract that I can customize for clients, and I basically made a table of contents, and it is not very huge type, but here it is. So first of all, what we're going to see is one of our components of such a contract is that there's going to be a grant of rights. And this is kind of like that CLA that I mentioned, that contributor license agreement. It defines who has what rights. Oftentimes, if we are doing a contract of this nature, and this is true if you're writing a book, a movie script, orchestral piece, a video game, the next AI program, it doesn't matter. If you're doing something that has a copyright on it, then you're going to want to make sure that we know what rights the publisher has. And so do they have the right to translate it into a new language? Do they have the right to distribute it worldwide? Do they have exclusive rights? These things need to be clarified. And so that usually requires a lawyer and the team of people who are granting these rights to work together to work that out. We also need to have a method of delivery. How are the game developers or the musicians or whatever going to deliver that material? What obligations continue after the initial delivery? So if you are Taylor Swift, you might not have an obligation to update your song, but if you are creating a new antivirus software, you might have an obligation to make sure that it supports the newest viruses that come out. You're going to have to decide and specify in this contract who is going to provide what kind of support. Oftentimes, people who create these products are not that interested in providing the general support. And so a publisher may provide frontline support and then only escalate very challenging support questions to the creators. Consideration, this is a geeky law word. Consideration means that there has to be some kind of payment or other benefit transferred each direction. So I've created this work of art. I'm going to let you publish it. In exchange, you are going to give me something of value. It could be money, and oftentimes that's what we care about, but it can be something else. So it could even be, I'll let you do this as long as you promise not to sue me. That's what a settlement agreement says. But there has to be some kind of two-way transfer of value in order for such an agreement to exist. You need to think about sequel rights. If there's going to be a version 2, does the publisher get access to that? What about publication obligations? Let's just say that you make a contract and it's $50,000, I give you my game and you give me $50,000. Well, great. Does the company have to actually publish it, or can they just bury it, give you a check for 50 grand and then never release it? You want to make sure that that's clear. And so we see that with movie scripts sometimes, where things get purchased and never actually used. We need to know how long this agreement is going to go for, and then what happens if you want to break up. There also might need to be some confidentiality clauses. At the very least, you're likely going to want to see protections for any intellectual property, copyright, trademark, or whatever. Now, here's another one that is commonly not thought about enough, and I see people get into trouble with this all the time, and that is there needs to be a representations and warranties, even if the only warranty is there are no warranties. But there is this thing called implied warranties, and implied warranties basically mean by the nature of its existence, I expect it to do something. If you go to Walmart and you buy a toaster and you see a picture on the outside of the box of a toaster and toast coming out of it, it better make toast. And if it doesn't, then you've breached your warranty. You can't put a disclaimer in fine print on the box or inside the box that says doesn't actually make toast, because you've basically promised them it makes toast. So you need to clearly spell out what is promised and what is not being promised. Usually you want to have some discussion in the contract about damages and disputes. And so oftentimes we like to see people resolve matters quickly and efficiently through arbitration. That might not be the right way to do it. And then indemnification. If one party screws up, is the other party responsible? That needs to be there in as well. So this is kind of a short version of the things that I like to see in such a publication agreement. So thank you, Sam, for your question there. And so that is hopefully a pretty comprehensive answer, but ultimately you are going to want to talk to an attorney.